Case number 111554, State of Kansas v. Dooley.
May it please the court, Archie Dooley appears through me, Jennifer Roth. I work at the Appellate Defender Office. And Chief Justice, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
By way of the brief overview that the court has requested, Mr. Dooley was convicted of 3 sex offenses in 1998, for which he served a sentence of 38 months. From 2003 to 2010, he resided and registered as an offender in McPherson County. In 2011, he was charged with failing to register, which is a severity level 5 offense at the time, for failing to report a change in his address. He pled to that crime and was sentenced in 2012. The district court put him on probation using the factors that the parties agreed and that Mr. Dooley was not a threat to society. From 2012 to 2013, Mr. Dooley was on probation and admittedly committed a number of technical violations and received some 2 and 5 day sanctions as well as a 30-day sanction.
So you agree that the first of the graduated sanctions occurred?
I do.
Okay, thank you.
And so in December of 2013, the Community Corrections Probation Officer filed an affidavit on December 17th alleging a number of violations that Mr. Dooley was alleged to have committed. He stipulated to those. Let me back up. They had a hearing, a probation revocation hearing on January 24th. At that time, he stipulated to some of the allegations. There was some testimony, and the district court ultimately concluded that Mr. Dooley had several chances and sentenced him to 120 months, which constitutes a sentence almost 3 times longer than the crime for which he registers. So that's the summary, although it's kind of longer than I expected. It is our contention that this court should reverse Mr. Dooley's Court of Appeals case for 4 reasons. The first is that everyone, the Court of Appeals, the state, and us, agree that the district court did not make the required finding. To borrow the words of Justice Beyer just a moment ago, the court did not follow the process. That is our contention. The second reason that this case should be reversed is that the Court of Appeals did not follow its own law.
Let me stop you there. The court did not make the appropriate finding. Are you talking about the C9 finding or the C8?
The C8.
Okay.
And in fact, most of I'm prepared to talk about C9 as well, but all of the arguments that we made were about the C8, which is of course the absconding. The state in its initial brief said, oh, well, you know, the court could have made these other ones too. I have plenty of things I could say about that, but I'm basically focusing on C8 unless the court wants to talk otherwise. So the Court of Appeals in its decision didn't follow its own law. It didn't follow, in addition, it didn't follow its own law. It didn't follow 2237-16. And the case that it cited and didn't discuss is distinguishable from Mr. Dooley's. The third reason that this court can reverse and should reverse is that the record doesn't support an absconding finding. And the last thing I would say is if this court wants to take up the issue that the state brings up in their supplemental brief, which is this idea that you should get rid of the Huckey definition and come up with either North Carolina or the compact or something else, that my response to that is that you all have already decided this. You decided it before Huckey. You decided it in Rayburn. So those are the 4 reasons that I would like to discuss as to why this court should reverse this case. As I mentioned, everyone agrees that the district court did not make the required finding. Everybody admits that the court did not reference C8 It didn't use the word absconding. It didn't even reference not reporting. I don't think this matters as much, but it didn't check the box on the journal entry that says we're relying on the C8 exception. What the court did is it fell back on the no longer approved language of you've had your chances and now you're going to go to prison. That is no longer what the law says. As we all know, the legislature has made a system of graduated sanctions, and this sort of general language of I'm done with you, you've had your chances, is no longer permitted. The second thing that nobody seems to argue is that Huckey has a procedure and that procedure is fine. Nobody, the state does not argue that the course of conduct that a district court's supposed to take as set out in Huckey, that's wrong. The three-step process being that the state has a burden to raise the absconding exception. Number two, that the state has to prove it at an evidentiary hearing. And number three, the court has to make a ruling. Nobody seems to argue that that is the procedure. Yet that procedure was not followed. That process was not followed in this case. The allegations that were put forward by the probation officer said that Mr. Huckey didn't report to the community corrections for his intake, and he apparently absconded. That was the way that it was raised. At the hearing itself, while the state did mention absconding, they did not ask for the C8 exception to be applied. And the bottom line is the court did not make a ruling. They did not follow the process. So then we get to the Court of Appeals, which I forgot to say in my summary, that obviously we're here today because Mr. Dooley lost in the Court of Appeals, filed a petition for review, and you all accepted that petition, and that's why we're here today. And it is our contention that the Court of Appeals did not follow its own law, nor the graduated sanction statute, and the case it does mention in its opinion is distinguishable. First of all, the Court of Appeals also agreed that the district court failed to specifically state at the hearing that it was revoking because Dooley was an absconder. And then the court says, well, it accepted on the record Dooley's stipulation that he was an absconder. Mr. Dooley did not stipulate to being an absconder. He stipulated to the allegations in the affidavit, which included a preliminary allegation that he apparently absconded. That is not the same as actually absconding. And second of all, Mr. Dooley cannot stipulate to a legal finding that the court required, the court that makes the that made the Huckey decision, you cannot stipulate to a legal finding that a court is supposed to make. You can stipulate to facts underlying it. You can testify about what you did in December and January, which is what Mr. Dooley did. But you cannot stipulate to this legal conclusion that a court is required to make. The second error I would say that the Court of Appeals made in their opinion was that the journal entry states that Dooley's probation was revoked in part because he was an absconder. First of all, I maintain, this is why I said I don't know that the journal entry is as big a deal. It does help people who are reading it. But the journal entry, in our argument, is it doesn't control. You look at what the court said on the record. And what the court said on the record had nothing to do with absconding. It was that standard bygone language about how I'm done with you, you've had your chances. The other thing that strikes me is that journal entries are drafted not by the court. They're drafted by the state. So that's my experience. And that what is in the journal entry that the Court of Appeals seems to give so much weight to is basically copied from the affidavit. But the box about using the C8 exception is not checked. The third error that the Court of Appeals, in our opinion, is their reliance on State v. Crossland. Interestingly, the Court of Appeals never even cites Huckey. It doesn't talk about what needs to happen when you want to rely on C8, when the district court wants to rely on C8. But what the Court of Appeals does reference is an unpublished case called State v. Crossland. And they found this to be persuasive. They didn't discuss it, They just said, hey, in Crosland, the district court also wrote in the journal entry that it made this finding. But this is also an error because Crosland itself is distinguishable. In Crosland, the probation officer actually tried to find Mr. Crosland. Mr. Crosland admitted that he didn't report because he had a warrant. And that, of course, meets the definition of absconding. So even the case that the Court of Appeals cites is distinguishable from Mr. Dooley's.
Didn't Mr. Dooley say he didn't show up because he was scared?
He did. He did not show up to his Oxford house, which is like a halfway house. He didn't show up.
That's pretty close to not reporting because you have a warrant.
Well,
it's pretty close to I didn't show up because I was
scared
of trouble.
I was scared of what was going to happen.
Mm-hmm.
I couldn't get into the halfway house. I didn't have the money. Mm-hmm. And I was scared of what was going to happen if I didn't show up. Mm-hmm. So I've thought about that.
It's got the same flavor, doesn't it?
It does. But the other thing I forgot to mention in Crosland is not only did he say I didn't show up because I had a warrant, he also went to Oklahoma. Mm-hmm. And they tried to find him, which I think those things are important.
I mean, there's more evading the legal process there, but we're getting dangerously close to.
Yeah, and I agree. It is, when you say I'm scared, you're saying you're scared of a consequence that might come to you because you didn't get to the halfway house.
He wasn't afraid he'd be shot. He was afraid that the legal
what
process
consequence
would happen.
Right.
Okay.
He's trying to avoid detection. Is that what you're saying?
No. And in fact, there's no evidence about what we know is that Mr. Dooley didn't go to the community corrections on December 6th. And then he turned himself in to the community corrections office on January 14th. And he testified that in between that, he was scared that he didn't get into the halfway house, which we can presume he means I'm scared about what's going to happen if I didn't get into the halfway house. But we have no evidence in between there that he wasn't at an address that his probation officer had. There's no evidence that somebody went to look for him. There's no evidence that he went anywhere other than the county he was supposed to be. There's no evidence other than what he himself was explaining he was doing in that time that ended with him turning himself in a month later. The one thing I would say is there was one other piece of evidence in addition to him being scared. There's the piece of evidence where the state said, well, did you ever call and ask community corrections if they'd help you pay to go to the halfway house? And he said, no, I never called him. But there's no other evidence about what steps they took to find him. There's no evidence that he was failing to register, which I think the state was trying to kind of hint at. There's no evidence about what else he did between December 6th and January 14th when he turned himself in, other than what he has provided. So we don't know if the probation officer went to look for him. We don't know if he was at one of the addresses that they had. None of that is in the record.
Is it your position that we look to Rayburn to define what absconds from supervision means? Rayburn really stood for an entirely different premise. What we were trying to define in Rayburn was what satisfies absconding when you're a fugitive from justice. What disentitles you to an appeal when you're gone. That's what we were struggling with in Rayburn. This seems to me something less than that. And tell me why it's not less than that.
Well, first of all, I agree that Rayburn came to you on this idea of the felony disentitlement.
Fugitive disentitlement.
Right, fugitive disentitlement. But the whole point of Rayburn was, did this person abscond from supervision? So
no, it was from jurisdiction of the court, I think we were looking at.
But what...
Initially identified by he never showed up for probation to his probation officer. But that led to the conclusion that he was.
But I thought that this court that the way that what you had to actually determine was whether or not he absconded from probation. I understand it came to you in a different way. But what you looked at is whether he had absconded from his supervision. But even if this court thinks I'm relying too much on the fact that you've considered Rayburn in the past, we think that you should follow Huckey. And there's nobody that's saying the process of Huckey is wrong. The state is asking you in its supplemental brief to change the definition. But if nothing else, then we would be asking you to follow Huckey if you think that Rayburn is not that applicable.
So you're saying that the failure to appear where he was supposed to appear as a condition of probation is not absconding if his whereabouts is known and he can be picked up for the violation by simply driving out and getting him. He hasn't complied with conditions, but he hasn't absconded from that supervision. Is that what you're trying to argue to us?
What I'm saying is, when you fail to report, that absconding has to be more than that, because otherwise it would render this graduated sanction system superfluous, to borrow another court word. Because if it was just that you failed to report, then anybody who failed to report would go straight to prison, and that is not the point. So the point of the graduated sanctions is that if you abscond, then you can not follow them. So I guess to answer your question, it requires more than not reporting. And for example, in Rayburn, it was about, did you try and find this person? And the Court of Appeals has taken. And the state, here's the thing, the state is correct in its supplemental brief when it says that different courts use sort of different considerations to determine whether the person truly absconded or not. That's just how it works. I mean, it's true that it's a case-by-case basis. But at the bottom line of that, there is that it has to be something more than not reporting. It has to be more than that. That's what Huckey says. That's what the graduated sanction statute would require to make it mean anything. And so and then specifically to Mr. Dooley, I'm arguing that there was not evidence that he absconded.
On that point, counsel, very quickly, I do understand you to be making two separate arguments. One, a process argument, district court abused its discretion by not announcing on the record, and the other, a sufficiency of the evidence argument. Did you make that sufficiency argument at the Court of Appeals? Because I don't see any discussion. Maybe I'm just missing it, but did the Court of Appeals discuss the sufficiency question?
Oh, no.
Did you make that argument to the Court of Appeals?
If I could, I didn't write this, but I just looked at it again before I got up here. The argument that we made in our brief original to the Court of Appeals was that the court did not revoke using they didn't name the C8
Right.
exception.
The process argument.
Right. And then the next paragraph is that the bypass provision did not apply in this case. And then that's where we argued that apparently absconding is not actually absconding, and that the state must present evidence that he fled, hid himself, deliberately acted to avoid arrest, prosecution, or service of process. And then in our brief it says the state did not present any evidence that Mr. Dooley actually absconded. And so I believe it is brief, literally, but I believe that is an argument that we made.
Thank you.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, Chris Ailslager of the Attorney General's Office, appearing on behalf of the state. And this morning I'm pinch hitting for the McPherson County Attorney who had a conflict today. And as I listened to my opposing counsel's argument, I began to wonder if maybe the McPherson County Attorney pulled a fast one on me, because, I mean, if we're all in agreement that the district court screwed up, then why am I here? So I think she's guilty of a bit of overstatement there. I don't think that the state has ever agreed that the district court screwed this up. I think we've agreed that, or we've argued all along that the district court got the right conclusion and did not abuse its discretion, and that the Court of Appeals got it right.
I think
Did it get there by the right route?
Well, I believe so. I mean, I guess the argument is that technically the district court didn't state some specific talismanic language on the record, but from my understanding of the case, the court stated on the record that it found that it accepted Dooley's stipulation that he absconded, and that was in the journal entry, and when you look at the context of the hearing, that is enough to meet the particularization.
Let's talk about the
requirements.
context a little bit. I think your opposing counsel said that Mr. Dooley's response regarding apparently absconded was just an agreement that that is what had been alleged, rather than an agreement that he in fact did so.
No, I
you have a
believe that when
response to that?
he stipulated to the fact, and I would say that absconding is not a legal determination, that's a factual determination. He wasn't where he was supposed to be.
Let me be clear, Mr. Isliger. What your opponent has said is that that passage in the transcript is merely his acknowledgement of what had been alleged, not a factual admission.
Yeah, I disagree, because I mean, if he was stipulating that he had violated his probation, he stipulated that the allegations were true, and that I think actually his statement was along the lines of something like, "Yeah, I'm guilty," something like that in the record. And I have to profess that because I am pinch hitting today, I am not really up to speed on the record. I have to rely on what's in the briefs and in the Court of Appeals argument, or the Court of Appeals decision. But I believe in the Court of Appeals decision, they quoted him as saying that. And to me, if he stipulated to the truth of the allegations of his probation violation, which included that he did not report his whereabouts and had apparently absconded. And I think the word apparently, that adverb there, doesn't water it down any. It means that to all intents and purposes, to anyone's knowledge, he had absconded. He was avoiding supervision. And I think he also said that the reason he couldn't get into the halfway house, and so he didn't contact his probation officer or anything, as you pointed out, because he was afraid of the consequences, which is very similar to someone trying to avoid arrest or prosecution. Now, this is where we get into why we think the Huckey definition of absconding, relying on Rayburn, is a bit wrong in the context of a probation violation, because obviously no arrest warrant or prosecution had been issued yet because he was on probation. He just surmised in his head that because he didn't do what he was supposed to do, that if he reported, he would get in trouble, and he didn't want to face that trouble.
What's the distinction between failure to report and absconding from supervision? I mean, there has to be a difference.
I agree. There does.
So what's the difference?
I think you have to look at facts that evince an avoidance of supervision, which is what both the North Carolina definition looks at, and the Interstate Compact on Adult Supervision, which is a compact that Kansas is a part of, and thus is actually part of Kansas law. And there is a definition of absconding there, and that definition is to be absent from the offender's approved place of residence or employment and avoiding supervision. So I think the key piece there is avoiding supervision. All right. So if he's taking steps,
What was the first part of that? Read that again.
to be absent from the offender's approved place of residence or employment and avoiding supervision.
And it's conjunctive.
It is conjunctive.
And
So-
you want to argue disjunctive, is what I'm hearing. You want to argue just the
Well-
avoidance of supervision, not the fact that he's still living at his approved house.
Actually, I think in this case, I passed earlier because I think in this case he wasn't where he was approved. He was supposed to be at the halfway house and he wasn't there, is my understanding of the record. But I think the key is the avoidance of supervision. A guy can be absent from his residence or from his place of work for some reason or another. Perhaps he got in a car accident, had to go to the hospital. Well, he's not avoiding supervision at that point. But in this case, he was clearly avoiding supervision. He said so. He didn't want to face the consequences of not going where he was supposed to go and doing what he was supposed to do.
I see those as two different concepts, and I'm still struggling with the difference between failure to report and your definition of absconding. I understand there could be a factual situation where someone can't get a ride and doesn't report because of that. But in most situations, if it's just, hey, I'm just not feeling like going in today, I'm not going to go in, why doesn't that meet your definition? Yet that's just a technical violation of a failure to report.
Well, I think it requires a case-by-case factual determination. If the person just doesn't report once and then reports the next week, obviously that's not absconding. It's if the person takes steps to avoid supervision. And if you look at the Huckey definition, requires some kind of sudden and secretive departure to avoid arrest or prosecution. And I don't think that we require them. That it's required that the person pick up in the middle of the night and stow away in a secret compartment in a vehicle somewhere and drive across state lines to be an absconder. The person can still be in the same city where they live, but just avoiding supervision, meaning there has to be some evidence that the person has taken steps to avoid supervision by the probation officer or has evinced an intent to avoid the supervision or the consequences of supervision, as has happened here. Mr. Dooley stated that he didn't want to face the consequences. That's why he wasn't reporting. That's why he didn't contact the probation office. That's why he wasn't where he was supposed to be. So I think you do need to have some other evidence than just failure to report. The state agrees with that. We think, though, that the evidence can be the threshold is that we have to show that he's avoiding supervision, not that he departed suddenly and secretly in the middle of the night.
It has to be intent, though.
I think there has to be some intent.
Yeah, I mean, the avoiding supervision still has to be the intent, which to me gets you right back to my old Webster dictionary, which I looked at a couple days ago, which talks about avoiding detection. I mean, that's really what we've got to have, that extra element, right? Failure to report and trying to do something to avoid detection.
I'd agree.
In order to avoid
some kind of avoidance, yeah, right. And I think even if I recall, like even in the Huckey case, the person ran into the probation officer like at a gas station, and they said, "Hey, you need to report," and then she did.
So what do you think you have here, where the defendant's trying to avoid detection?
Well, I think we have his own statements. I mean, first off, he stipulated to it. He agreed that he did.
Yeah, I've got problems with that, but I don't want to hang you up into the particular back and forth, because I know you're showing up here a little cold, and I'm not sure I agree. I think it's the way I read the record is the court said, in fact, I wrote it down here, is so you understand those are the allegations contained in the motion, and Dooley says, yes, Your Honor. Now, we have to agree that's not a stipulation. So, I mean, you would agree with that?
Yeah.
When the question is prefaced, you understand those are the allegations in the motion. You haven't stipulated by saying, yeah, I understand that.
Yes, I would agree with that.
So the best you've got, it seems to me, is the state's question on cross-examination, which is a leading question. You said the reason you absconded was because you were scared. And Dooley responds, well, yes. To me, that's the best you got.
And I thought, and from reading the Court of Appeals opinion, I thought that somewhere in there he made the statement that when the allegations were read to him, yes, I'm guilty or something like that. But I'm going to have to defer to you, and you have the record. I don't. I'm relying on the Court of Appeals opinion, and I'm assuming that they got the facts right. And I don't recall seeing any argument from the other side that they got the facts wrong. Other than the argument that the adverb apparently doesn't
Counsel,
actually equal.
can I take you back to that stipulation? And
Yes.
let's just assume that I agree with you, or we agree with you, that this was, the word apparently doesn't matter. We take the Court of Appeals view that he stipulated that he absconded. My question is, doesn't this entire discussion about whether we follow Huckey or the Interstate Compact, what's the legal definition of absconding, doesn't that entire discussion illustrate why we don't allow defendants to stipulate to legal conclusions? And so how is this not a legal conclusion? And so even if we take the most favorable view, your view as to what he was doing, he can't stipulate to that legal conclusion, can he?
You stipulate the facts. And I think whether a person has absconded is a fact. Okay, I mean all facts require a definition, but I mean it's still a fact. And to the extent that there's any kind of legal conclusion, he had counsel there to ensure that he didn't stipulate to a legal conclusion, didn't wrongly stipulate to a legal conclusion. We can't ignore the fact that counsel was there, but I still stand by the fact that whether a person has absconded is a fact.
Well, I understood you to say earlier, everything has to stand on its facts. If you didn't report this time, but then you reported next time, that wouldn't be absconding. Now, those are facts that you're applying to get the legal conclusion from those facts, aren't you?
Well, yes. Ultimately, I mean, all of the facts will lead to a legal conclusion.
And that leads me, if he, your position is if he missed today, but he showed up later, that wouldn't be absconding. Here we have failure to show up at the halfway house on December 6th and January 14th voluntarily showing up. So what's the difference between your example and what actually happened here?
Well, first off, my example is just shooting from the hip as I stand here. But I think that, again, as I said, each case I think is dependent on the particular facts, on what what actually happened. I don't know how many times he was required to report in between there. I don't know if he was given instructions that if you can't get into the halfway house, you need to call the probation officer. That may be in the record. But I think, again, part of it goes to the point that was pointed out over on this side of the bench, is that there has to be some kind of intent. I think there has to be evidence showing some kind of intent to avoid detection or avoid supervision.
So the fact really that you're focusing on is that he said, I was scared, I didn't show up because I was afraid of the consequences.
I think that is correct.
Absconding is a legal conclusion. It's a term of art, right? Legal term of art. But the underlying facts you're saying are adequate here. He didn't show up, and he said, I didn't show up for this reason. And that equals, that plus that equals absconding as a legal conclusion. Anyway, we don't need to get any more hung up on it, I don't think.
If there are no more questions, that concludes my argument. I simply ask that you affirm the District Court and the Court of Appeals.
Would you agree that when a statute requires reasons to be set forth with particularity, it's counterintuitive to say you can imply from statements that the court made those findings, made those reasons set forth? I mean, particularity has to mean something, and it doesn't mean by implication, in my view, but I want you to argue why I'm wrong.
I think it requires some specificity, but I'm not sure that it requires a checklist or talismanic language. And I think that the specificity is here when the court accepted the stipulation that included the allegation that he absconded, and I believe it was noted in the journal entry that he absconded. So I think that's enough.
Any more questions? Thank you, counsel.
Thank you.
I just had three things I wanted to conclude with. The first is that I feel that the state, through some responses to your questions, is actually helping make my point, which is that the record here does not have enough for the district court to find that our client absconded. The state says, well, I don't know if he was supposed to, how many times he was supposed to report in that period. I don't know if he was supposed to let his probation officer know if he didn't get into the halfway house. There's all sorts of things that we don't know from the record that is before us. We'd know even less if our client hadn't taken the stand to explain things and give the justification of why he wanted the prison sanction. The state didn't call any witnesses. The state didn't cite to the statute. The state didn't call the probation officer. So we'd have even less of a record if our client hadn't explained himself. So for that reason, it is our contention that the record would not support this finding anyway. The second point I want to make is that the state is arguing that the Huckey definition, they want you to instead consider the North Carolina definition or perhaps the compact one. If you read the North Carolina cases that the state cites and includes in their own supplemental brief, you can see that North Carolina grapples with what does it take, just like Kansas does. And so having a different definition doesn't change the fact that you'll still have to do a case-by-case determination, which the state said, and that second of all, North Carolina grapples just as we do in trying to determine what constitutes absconding. But the last thing I would say is that the words that the district court used are very telling. They said that you were given several chances, and so now I'm sending you to prison. They didn't talk about the statute that they didn't make the finding. They didn't refer to it. There's no way you can construe that what the district court did with that statement was make an exception under C8. They did not follow the process. Number two, again, we don't believe the record would support an absconding finding, but Also, the way the Court of Appeals took on this case, they spent the bulk of their factual part talking about all of our clients' violations and his sanctions, and even started the opinion with, after being formally sanctioned and having his probation revoked and reinstated once. Here's the thing. House Bill 2170 has been the law since 2013, and courts are going to struggle with what is absconding, and people are going to be annoyed, the state, the courts, they're going to be annoyed when people don't follow the rules and make technical violations. That is frustrating, that is annoying, but the law requires certain things. The legislature has told us that we're going to have this system of graduated sanctions, and if the state wants to argue otherwise, or the state wants to argue for a different definition, then they can take that up across the street.
What is the remedy you're seeking? For us to define absconding and send it back. What are you asking us to do?
I feel that absconding's been defined, and again, if anybody wants to say otherwise other than Huckey, they can take it up with the people across the street. What I would ask for, my initial reaction was that I was asking this court to reverse and reinstate this man's probation, because we do not believe that the record would support the finding. I suppose that maybe this court will say that's not the right remedy and that maybe he should get a new hearing, but based on the record as a whole and what has happened here, it is my request that it be reversed and that his probation be reinstated.
Thank you.
Counsel, I'm going to ask you a question similar to what I asked counsel in the earlier case today. I believe you were present in the courtroom for that argument.
I was.
In your view, what is the minimum that had to been established factually by the state to demonstrate under C8 that the defendant absconded from supervision?
I think that if I'm remembering all the parts of Huckey and the cases that Court of Appeals has decided, true that they would look at the fact that he didn't report to the community corrections people, but they would also have to establish that he did something more to secret himself, that he that there were efforts made to find him, and not exhaustive efforts, but that there was some sort of effort to locate him, to try and contact him. I mean, even a phone call, something like that. And I also think that it's, if there had been evidence that he didn't turn himself in and that they picked him up somewhere, and that's how this thing got into court, that would be evidence that he possibly, so I feel like I'm not doing a very good job answering your question, but these are the sorts of things that I think a court can consider, but they have to talk about those things. And in this case, there wasn't even any evidence as far as what else he did besides not report, other than what came from him. And so I think at a minimum, the court would have to hear some evidence put on by the state, and then make a decision about whether he went beyond not reporting.
Why can't not the state rely entirely upon the defendant's testimony that I did not show up because I was scared and I deliberately stayed away all those days and I hid myself in my closet or I only went out at night? Why isn't that sufficient? Why does the state have to have other evidence?
And that's true. I know that Huckey says the state has to have, put on the evidence. The fact is, I agree with you, Chief Justice, that it would, if you could just take everything that the defendant said. In my experience, we hardly ever had hearings. We always just agreed that the people violated their probation and we focused on the disposition. So I don't disagree that you could take everything and just use what the defendant said. And in fact, that's what happened in that, I don't know if it's solely based on what he said, but in the Crosland case that the Court of Appeals cited. But even when you take the defendant's own words, there has to be more than, I was scared about what would happen, and so I waited 6 weeks and then I turned myself in. That there are other inquiries that need to be made and facts that need to be considered that this record doesn't have.
Isn't it back to what my colleague said avoid detection. The fact that inaction isn't enough, there has to be something that would further the avoidance of detection.
Right, and we don't have any evidence of how he avoided detection. I mean, all the time, my people would get like picked up at their grandma's house where the probation officer knew they were. There has to be evidence of the person trying to secret themselves or avoid detection or avoid supervision. And so, and that's not present here. And that is the key part, and that's the key part that's missing here. If they had been able to say, listen, I called you, I sent you a letter, I went to the place where you were supposed to be, I went to the place where you worked, something like that. We have no idea what else this gentleman was doing or not doing between December 6th and January 14th when he turned himself in. And that's why it's just not sufficient in this instance.
Very well, thank you.
Thank you.
Any more questions? I see none. Thank you, counsel.
you.
We thank you both for your arguments this morning. Court will take this matter under advisement. This time the court